Hello friends, welcome to the world of Companies Act 2013. I, Professor Kunal Shah, is over here to present you all the revisionary lecture towards chapter number 4 of Companies Act 2013. Yes, my dear friends, chapter number 4 of Companies Act 2013. Chapter number 4 of Companies Act 2013 deals with share capital and debentures. Over here, this entire chapter covers the provision from section number 43 up to section number 72 of Companies Act 2013. In our revisionary lectures, we are going to cover the important provisions towards this chapter. Yes, my dear friends, we have also covered the amendments which has been there in your RTP which has been issued just now. That is the RTP which has been applicable for November 21 exams for Inter CA, which is now been scheduled to December 2021. So these revisionary lectures are complete revisionary lectures along with the amendments which are being given inside the recently issued RTP for November 2021 attempt. Over here we have got a topic called as share capital. First of all, what do you mean by share capital? The lawmaker here over says that the capital which is been raised by issuing shares. See, whenever a company is in need of money and the company wants to raise the funds by issuing shares, the company over here can either issue equity shares or the company can either issue preference shares. Whichever is the share the company issues and the capital gets raised, the money forms part of a share capital account. The money forms part of a share capital account. Over here, whenever we talk about share capital, so yes, whenever the company has issued equity shares or preference shares and the funds are being raised, then that money forms a part of share capital. First of all, let us revise classification of share capital. Let us revise classification of share capital. A share capital can be classified into various headings. There can be something called as authorized share capital. What is an authorized share capital? We have already understood this thing in our chapter number 2 under a topic called as Memorandum of Association under a clause called as Capital Clause. Authorized share capital is the maximum share capital the company can issue. Sir, why does a company issue shares? The only reason of issuing the share is to raise the funds. So whenever I talk about the issued capital, always and always remember that issued capital will be lesser than authorized share capital, or it will be at par as compared to authorized share capital. Sir, can issued capital be more than the authorized share capital? The answer is no, and this concept we have already understood in our accounts as well. For example, the company has got an issued capital of 10 crore shares of rupees 10 each. The company has got an issued capital of 10 crore shares of rupees 10 each. However, the shares are being issued at 100 rupees, means the shares are being issued at premium. We are not over here to discuss the issue price, we are over here to discuss about the classification of share capital. So the issued capital of the company over here is 10 crore shares of rupees 10 each. This is the capital, this is the shares the company have issued. For example, this entire issue got subscribed. The entire issue got subscribed. So whatever were the shares issued by the company, all those shares were being subscribed by the investors. See, the minimum subscription has to be 90%, but over here it is 100%. It is 100%. If there is an oversubscription, then the allotment will be done on pro rata basis, which we have already understood in our accounts. Let us take an example that the company issued 10 crore shares and that entire 10 crore shares were being subscribed. That entire 10 crore shares were being subscribed. Right now, the face value per share is 10 rupees, but company has called up only 7 rupees per share right now from the investor. So that is the called up capital. 3 rupees company will be calling up, but it is right now not been called, it will be called in future. So company has made a call of rupees 7 per share. However, the investor have just paid rupees 5 per share. Investor have just paid rupees 5 per share. So over here, whatever is the money the company has already received is called as the paid up capital. The money which the company is yet to receive but already been called is called as an unpaid capital. Over here, let us move on ahead towards the next part, that is the definition of the word shares. The word share is been defined under section number 2, clause 84. Section number 2, clause 84 of the Companies Act 2013 defines the word called as share. The lawmaker says share means a share in the share capital of a company. A share is a share inside the share capital of a company, and it includes stock as well. It includes a stock as well. See, for the sake of example, if I tell you that I'm having 500 shares of Reliance, if I tell you that I'm having 500 shares of Reliance, which means I've got some part, I have got some share inside the share capital of a company called as Reliance Industries Limited. So what is a share? A share is a share inside the share capital of a company. The lawmaker says that a share is not a sum of money. A share is not a sum of money, but it is a bundle of rights and liabilities. A share is not a sum of money, but it is a bundle of rights and liabilities. So what will be my liability with the company over here? The lawmaker says if the shares are partly paid up, then in that case your liability will be towards the unpaid value of the shares. Okay sir, what is the liability we have understood, but what are my rights? The lawmaker says if the company is into a going concern and the company declares the dividend, then you being a shareholder, you are having a right to demand that dividend. However, if the company goes for a winding up, then in that case, you being a shareholder, you will be having a right to participate into the assets of the company. You will be having the right to participate into the assets of the company. So is a share a bundle of money? No, a share is not a bundle of money. In fact, a share is a bundle of rights and liabilities. Shares can be held in two ways. It can either be held in a dematerialized form, that is nothing but electronic form. Shares can also be held in physical form. If your company has gone for a public offer or else any such other class of companies, then for all of them it is mandatory to issue securities to dematerialized form. But for any other company, the securities can be issued in physical form. See, if the company has issued the securities in a physical form, then in that case, the share certificate itself will be acting as a proof of ownership. But if the shares are being held in a dematerialized form, and if someone is going to ask me that whether you are a shareholder of that company, I say yes. What is the proof of ownership over here? The proof of ownership over here is the records of the depositories. Yes, there are two depositories, one is NSDL and another is CDSL. All these depositories will be linked through various depositories participants. It will be linked through a depository participants. So if the securities are being held in a dematerialized form, then the proof of ownership is the records of the depository. But if the shares are being held in a physical form, then in that case the share certificate will be acting as the proof of ownership. The share certificate will be acting as the proof of ownership. See, whenever the shares are being held in physical form, then in that case the lawmaker says that every share should be distinctively numbered. Every share should be distinctively numbered. But if the shares are being held in a dematerialized form, then in that case we don't require to give a distinctive number if the shares are being held in a dematerialized form. Let us move on ahead towards the next provision, which is upon section number 43, which says about kinds of share capital. See, when I say shares are of two kinds, then in a similar way share capital will be also of two kinds. Yes sir, we know shares are of two types. One is a preference share, another is an equity share. One is a preference share, another is an equity share. See, whenever we talk about a preference share can be further classified on the basis of dividend, wherein it can either be a cumulative preference share or a non-cumulative preference share. It can either be a participatory preference share or a non-participatory preference share. A preference share can also be classified on the basis of convertibility, wherein it will either be something called as fully convertible preference share or partially convertible preference share. Such conversions can either be mandatory or it can even be optional in nature. A preference share can also be classified on the basis of redeemability, wherein it can either be a redeemable preference share or irredeemable preference share. However, the concept of irredeemable preference share is been completely scrapped off. When I talk about equity shares, yes, equity shares can also be further classified. It can be equity shares with voting rights, or it can be equity shares with differential rights to dividend, differential rights to voting, or otherwise, which has been considered as DVR, that is equity shares comprising of differential voting rights and differential rights to dividend or otherwise. Yes, we will be discussing about the concept of DVR within few minutes. We will be discussing the concept of DVR. Let us move on towards the next concept, that is about preference shares. See, whenever I say that falana share is a preference share, whenever I say that this particular share is a preference share, then always and always remember that a preference share is a preference share which fulfills the following two conditions. Which are the following two conditions which are required to be fulfilled? Only when both of these conditions are being fulfilled, then only we can say that a preference share is a preference share. Then only we can say that a particular share is a preference share. A preference share is a share which carries a preferential right in respect of payment of dividend. it carries a preferential right in respect of payment of dividend. So whenever the company is going to declare dividend, the very first right to receive the dividend will be towards the preference shareholder. If you are a preference shareholder, then you have got a preferential right towards the repayment of capital as well. If the company goes for liquidation, the assets will be sold off and the liabilities will be paid off. If any kind of surplus assets are being left out, then such surplus assets will be utilized first to repay the preference share capital and later on towards the equity share capital. So in a very simple terminology, preference share capital must have priority towards the dividend as well as capital. So whenever you are enjoying some kind of priority in receiving dividend and priority in receiving repayment of capital, it simply means that you are a preference shareholder. It is section number 55 of Companies Act 2013. It is section number 55 of Companies Act 2013 which deals with issue of preference shares. It deals with issue of preference shares. Whenever a company wants to issue a preference share, then in that case, first of all, it should be authorized by passing a special resolution by calling a general meeting. Over here, the company needs to call a general meeting, pass a special resolution, then only the company can issue a preference share. The lawmaker over here says that preference shares can be issued by a company only when the company has no subsisting default. Subsisting stands for existing. There has to be no subsisting default towards the redemption of preference share or towards the payment of dividend. There should be no existing default either towards the redemption of preference share or towards the payment of dividend The lawmaker says that a company is not allowed to issue a preference share which are going to get redeemed after the expiry of 20 years from the date of issue of preference share. No. So the maximum period under which the redemption should take place, it is by 20th year. Can a company issue a preference share which are going to get redeemed after 20 years? No. Can a company issue a preference share which are going to get redeemed within 20 years? The answer is yes. But wait. If your company is been engaged in setting up and dealing with infrastructural projects which has been defined under schedule number 6 of Companies Act 2013, then in that case your company can issue a preference share which can be redeemed even after 20 years but not exceeding 30 years. So the normal companies over here can issue a preference share which has to get redeemed maximum within 20 years. But if your company is been engaged in setting up and dealing with infrastructural projects which are been defined under schedule number 6, then yes, your company is allowed to issue a preference share which can be redeemed even after 20th year but maximum before 30th year. But in that case, just after completing the 21st year onwards, just after 21st year onwards or earlier, means expiry of 20th year, the company will have to start redeeming the part of a preference share. The redemption will be done on proportionate basis. For example, company over here has issued a preference share which is going to get redeemed at 30th year. So once 20 years expires, after that from 21st year proportionate redemption should start. Proportionate redemption should start. Yes, at last the lawmaker says that it may be noted that a company cannot issue irredeemable preference share. A company cannot issue irredeemable preference shares. So we have understood about the issuance of preference share. Now let us understand about the redemption of preference shares. Whenever a company is going to redeem its redeemable preference shares, then in that case the lawmaker says only those preference shares can be redeemed which are fully paid up. The lawmaker hereover says that the company can redeem preference shares either from the profits or through a fresh issue. Either the redemption can be taken place through profits of the company or it can be redeemed through fresh issue. Over here, if the redemption is going to take place out of the profits, then in that case the preference share capital will get reduced. So over here the company will have to transfer the equivalent amount of the money into an account called as capital redemption reserve account. So if the company is going to redeem preference share which is going to reduce the preference share capital by 100 crores, then 100 crore rupees will be first transferred to CRR account, and this amount will be utilized in future by issuing fully paid bonus shares. If the company wants to redeem preference shares at premium, then yes, the company can utilize securities premium account and redeem the preference shares at premium. But there are few class of companies whose financial statements comply with accounting standards. Those few types of companies cannot utilize securities premium account for providing premium on redemption of preference shares or debentures. Over here, the lawmaker says that if the company wants to redeem preference shares through further issue of a preference share by issuing a new share, then in that case the company needs to first take the consent of preference shareholder, that is 75% in value of the preference shareholder should give their consent, along with the approval of NCLT, However, if any preference shareholder is not ready to give his consent, then such preference shareholders can be redeemed forthwith, that is on immediate basis. Yes, over here the company needs to file the details to the ROC under a form called as SH7 within 30 days. The next provision we need to understand over here is about an equity share. The lawmaker says equity share is a share which is not a preference share. So the share which is not a preference share is called as an equity share. Whenever a company wants to issue DVRs, that is differential voting rights, then the company requires to fulfill the following conditions. The very first condition lawmaker over here have imposed states that the company is allowed to issue equity shares with differential voting rights only and only when it is authorized by the articles of the company. Yes, the company over here needs to pass an ordinary resolution. The company over here needs to pass an ordinary resolution by calling a general meeting. But wait. If the company is a listed company, then such companies will have to pass an ordinary resolution through postal ballots. So normal companies will have to pass ordinary resolution by calling a general meeting, whereas if the company is a listed company, that company will have to pass an ordinary resolution through a postal ballot. Always and always remember, after issuing equity shares with differential voting rights, the ratio of such share should not exceed 74% of the total post-issue paid-up equity share capital. So if the paid-up equity share capital is of 100 rupees, just for the sake of example, then the maximum equity share with differential voting rights can be of 74 rupees. The lawmaker over here have said the company should have not made any default in filing financial statements and annual returns for the three immediately financial years, for the three immediately preceding financial year. So if in this year, if the company is planning to issue a DVR, then in the past 3 years, company should have not defaulted in filing the financial statements as well as annual returns with the ROC. The lawmaker over here says the company has got no subsisting default either in payment of declared dividend or towards repayment of matured deposits or towards redemption of preference shares or redemption of debentures or towards the payment of deposits or debentures. There has to be no subsisting default in any of the following 4 places. In a similar way, the company has not defaulted either in payment of dividend to preference shareholders. The company should have not defaulted in repayment of any term loan which the company might have taken from a public financial institution or a state level financial institution or a scheduled bank. The company should have not made any kind of default towards the statutory payments relating to its employees. And the company should have not made any kind of default in crediting the amount towards IPF. What is IPF? We are going to revise it under section number 125 of Companies Act 2013. The lawmaker over here have said that the company should not be penalized either by the court or tribunal during last 3 years under any offence either towards RBI Act or towards SEBI Act or towards Securities Contract Act or towards Foreign Exchange Management Act or any other special act under which the company is being regulated by sectorial regulators. Yes, the company is being restricted for conversion of equity share with voting rights into equity shares with differential voting rights. If your company has already issued an equity share, that's the normal equity share, and later on your company issues an equity share which is a DVR, then both of them cannot be converted into each other. A normal equity share cannot be converted into equity share with DVR, or vice versa is also not allowed. In fact, whatever are the rights we are going to provide to a normal equity share, all such rights we also need to provide to an equity share with differential voting rights. In fact, the company over here will have to maintain the details of equity shares with the company will have to maintain over here the details about the equity shares with differential voting rights even inside the register of member which the company has maintained under section number 88 of Companies Act 2013. The next provision over here is about section number 47, which deals with voting rights of a member. See, if you are a member who is holding an equity share of a company, then yes, you are having a right to vote for every resolution placed before the company. In fact, if the voting is to be done by a poll, then in that case your votes will be in proportion to the share in the paid up equity share capital of the company. Higher your share inside the paid up equity share capital, higher the votes you will enjoy, However, if you are a preference shareholder, so yes, you are the member of a company, but normally a preference shareholder cannot vote. Normally, a preference shareholder cannot vote. However, in the following four situations, in the following four circumstances, a preference shareholder has got a voting right. That is, in case any resolution which is going to affect the rights of preference shareholders, then yes, for those resolution, a preference shareholder is allowed to vote. For those resolution, a preference shareholder is allowed to vote. In fact, any resolution the company is going to pass for winding up of the company, or else any resolution towards repayment or reduction of equity share capital or preference share capital, or else if the company has not paid dividend to its preference shareholders in any of the 2 years or more, then in that case every preference shareholder will be having a right to vote for all resolutions placed before the company. So only in the following four circumstances, only in the following four circumstances, a preference shareholder will be having a right to vote. Generally, normally, a preference shareholder does not have voting rights. Okay. If the voting is required to be done by poll, then in that case, a preference shareholder will be having a right to vote in proportion to his share in the paid up preference share capital of the company. So more your contribution towards the paid up preference share capital, higher the votes you will enjoy, higher the votes you will enjoy. The next provision is towards section number 48. Yes, in section number 48, there is a minute change given in your recently issued RTP for November 21 exams, which are now been scheduled to December 2021. So what is the change? The change is only and only towards the penalty portion. Yes, even in your JKC book, under section number 48, whatever is the penalty been written, you guys can omit that part. You guys can omit that part. So the penalty provision of section number 48 stands omitted. What is section number 48 trying to convey? Section number 48 talks about variation of shareholders' rights. Variations of shareholders' rights. See, whenever the share capital of the company is been divided into different classes of shares. For the sake of example, the company has issued Class A shares and Class B shares. Now, the company wants to change the rights of Class A shares. The lawmaker over here says if the company wants to change the rights of a particular class of shareholders, then the company needs to first take their consent in writing. The company needs to first take their consent in writing, which should not be less than 3/4 of that entire class. In fact, if we are going to change the rights of one particular class of shareholder, and because of such changes, if another class is getting affected, then we require to get the consent of even that class, which will be at least 3/4, of that entire class. However, if the shareholders of that particular class do not consent to such variation, then they can directly make an application to the tribunal within 21 days. However, it has to be at least 10% of that entire class who is not consenting and making a complaint to the tribunal. Over here, whatever is the decision of the tribunal, that decision will be binding upon the shareholders. It is the duty of the company to file the copy of the order of tribunal with the ROC within 30 days from the day when the order was issued by the tribunal. However, there used to be some kind of penalties, but that penalty is now been omitted. That penalty is now been omitted. Let us go on to the next provision, that is section number 52. Section number 52 deals with issue of shares at premium. Sir, can a company issue shares at premium? The answer is yes. Yes, a company is allowed to issue shares at premium. What is premium? It is a price which is above the face value. It is the price which is above the face value. It is the board of directors of the company. It is the board of directors of the company who will decide the rate of premium. See, whatever is the premium the company is going to receive, that premium cannot be treated as a profit. If you start treating it as a profit, then it should be made available for distribution as dividend. In fact, whatever is the premium the company has received, that amount the company will have to deposit in a separate account called as securities premium account. In fact, this is not to be considered as a free reserve, it should be considered as a capital reserve for the company. Sir, can a company utilize securities premium account? The answer is yes, but it can be utilized only for the following purposes. This can come as a theory question. This can come as a theory question. For what purposes securities premium account can be utilized? It can be utilized. What will be the purpose? So lawmaker says securities premium account can be utilized for issuing fully paid bonus shares. It can also be utilized to write off preliminary expenses. It can also be utilized to write off commissions paid or discounts allowed or expenses incurred for issuing shares or debentures. Or else it can also be utilized for providing premium at the time of redemption of preference shares or at the time of redemption of debentures. Or it can also be utilized at the time of buyback, However, there are few class of companies who can utilize securities premium account, but only and only for the following three purposes. So normal companies have got 5 places wherein securities premium account can be utilized. But certain class of companies can utilize securities premium account only for 3 places. That is either for issuing fully paid bonus shares, or else for writing off the commissions paid or discounts allowed or expenses incurred while issuing equity shares of the company, or at the time of buyback. Sir, what if the company uses securities premium account for a purpose which was not been prescribed? The lawmaker says if the company applies the share premium for any purpose other than those mentioned above, then it will be considered as reduction of share capital, which means the provisions of section number 66 will be made applicable upon the company. What is section number 66? We have already completed in our chapter number 2, which is towards reduction of share capital. The next provision we need to revise over here is the provision towards section number 53. Section number 53 clearly states that a company is being prohibited to issue shares at discount. A company is not allowed to issue shares at discount. However, following two are the exceptional cases. That is, in case of sweat equity shares, a company is allowed to issue shares at discount, or the company is issuing shares at discount to its creditors, wherein the company is going to convert the debt into shares as per the debt restructuring scheme which was been made as per the directions and regulations which are been specified by RBI. Directions or regulations which are been specified by RBI. However, if the provisions of section number 53 has been contravened, then in that case the company as well as every officer who is in default will be asked to pay a penalty which can be equal to the amount raised through issue of shares at discount, or 5 lakh rupees, whichever is less. In fact, the company will be asked to repay the entire amount to its shareholders with interest at the rate of 12% per annum. Over here, the next provision is about section number 54, which deals towards sweat equity shares, See, the concept of sweat equity shares, is given under section number 2, clause 88 of Companies Act 2013. Sweat equity shares means equity shares itself. But these are the equity shares which are being issued by the company either to its directors or employees, either at discount or for a consideration other than cash. See, the employee or the director must have provided their knowledge or must have provided their rights in the IPR, that is intellectual property rights. So in return, the company might have issued them some shares which will be at discount or for a consideration other than cash. Whenever the company wants to go for issuing sweat equity shares, the company can issue only those shares which were been previously issued by the company. Over here, the company requires to pass a special resolution by calling a general meeting. Over here, the company needs to communicate with its members about how many number of shares the company is going to issue through sweat equity shares. What is the current market price? What is the consideration the company going to receive? What are the class and classes of directors or employees to whom such sweat equity shares are going to get issued? In fact, if the company is a listed company, then the provisions of SEBI should also be followed. However, if the company is an unlisted company, then the rules prescribed by central government, should also be followed. Let us revise the next provision, that is section number 59. Section number 59 says about rectification of register of members on transfer of securities. See, whenever there is a transfer of securities, then yes, the register of members should get rectified. However, because of any of the given reason, if it is not been rectified, then in that case, the aggrieved party can directly make a complaint against the company towards tribunal. The aggrieved party may file an appeal towards the tribunal. However, if the aggrieved party is residing outside India, then in that case, aggrieved party can directly file an appeal to a competent court outside India. Once the matter is been filed, then the tribunal will either dismiss the appeal or else direct the company to transfer the securities within 10 days. Or else the company will be asked to pay damages to the aggrieved party. Over here, if the company makes a default in fulfilling the orders of the tribunal, then there used to be some kind of penalty upon the company as well as every officer who is in default. However, this penalty is been omitted. This penalty is now been omitted. So till now, under section number 48 and under section number 59, the penalties are been omitted. Let us move on ahead towards the next provision, that is section number 62. Section number 62 deals with further issue of share capital. Section number 62 deals with further issue of share capital. See, whenever the company proposes to increase its subscribed capital, by further issuing more shares, then in that case, company has got three options. Company can either go for issuing right shares, or else the company can go for ESOPs, or else company can fulfill the provisions of chapter number 3 of Companies Act 2013. Our main point of revision is towards the right issue. What is a right issue? The lawmaker says a right issue is an offer of a company's share to its existing shareholders. The company will be approaching to its existing shareholders and will be giving them offer that if you want to further have shares of our company, you can purchase those shares at this price per share. So right shares gives the first opportunity to purchase a new issue of the shares. Whenever the company comes for a right issue, then in that case the company is proposing to increase the subscribed capital by allotment of further shares. The company over here will be allotting further shares. Such shares which are being further allotted shall be first offered to the existing equity shareholders. Over here, the company will first give a notice to the existing equity shareholders by sending them a letter of offer. Such letter of offer will be given to every equity shareholders, wherein it is upon that equity shareholder whether he wants to accept the offer or not. The notice will be dispatched by the company either through a registered post or speed post or through electronic modes or through courier or any other modes which is having a proof of delivery. So any other mode which will be having a proof of delivery. The shareholder must be informed that they have an option to buy the shares of the company, wherein the company will provide them at least 15 days or such lesser number of days as may be prescribed. So this is an addition. So over here the words which are written in red has to be modified in your textbook as well. This is the new statement which has to be included inside your textbook. Over here, if the shareholder does not convey his acceptance to the offer, then it will be assumed that the existing shareholder have declined the offer of the company. If the articles of the company allows you, then you can go for renouncement. You can renounce your offer to any other person. Such renouncement can either be in whole or it can either be in part. Such renouncement will be done in the favor of some other person. Such renouncement will be done in favor of such other person. For example, there is a shareholder of a company named as Mr. X. He was being offered 500 right shares by the company. Now, if the articles of the company allows, then Mr. X can either renounce this entire right shares or he can renounce the part of the right shares. However, if Mr. X neither renounces nor he accepts the offer, then in that case it is the board of directors of the company who will dispose of such shares which will be in the most beneficial interest of the company. The next provision over here is section number 63. Section number 63 deals with bonus shares or capitalization of reserves. Either you say bonus shares or you say capitalization of reserves, it's one and the same. See, a company can issue fully paid bonus shares to its existing members. Such bonus shares can be issued either from the free reserves, or company can issue bonus shares through securities premium account, or company can issue bonus shares either through capital redemption reserve account. Okay, if the company had revalued the asset and there was something called as reserves getting created after revaluing the assets, a company is not allowed to issue bonus shares which has been made by capitalizing the reserves created by revaluation of assets. So assets revalued and reserves has been created, then such reserves cannot be capitalized for the issue of bonus shares. Bonus shares can be issued by the company only to the subject to fulfillment of following conditions. Number one, it should be authorized by the articles of the company. The bonus issue will be recommended by the board of directors. What will be the rate of bonus? Will it be 1:3, 1:10, 1:20, etc.? If the company has made any kind of default in payment of interest or principal amount, either towards the deposit holders or debenture holders, a company is not allowed to issue bonus shares. If the company has made any kind of default towards the payment of statutory amounts to its employees, the company is not allowed to issue bonus shares. If the company issues the bonus shares, then the bonus shares should be always and always fully paid up, and yes, other conditions which may be prescribed by law from time to time has to also get fulfilled, Let us revise the next concept over here, that is section number 68, which is towards buyback of shares and securities. Section number 68, which is towards buyback of shares and securities. The lawmaker over here says that buyback is a procedure which allows a company, to go back to its equity shareholders or specified security holders and offer them to purchase from them the shares or specified securities that they hold. So the company over here will give an offer to its existing shareholders that we are offering you that the company would like to purchase the securities which you are holding. Over here, why does a company goes for a buyback? What is the purpose for which the company goes for a buyback? The purpose for going for a buyback is number one, to improve earning per share. Or else the second reason will be to act as a defense mechanism wherein it will be acting as a safeguard against hostile takeovers. Or else the third reason can either be to provide an additional exit route to the existing shareholders because the shares are either undervalued or they are thinly traded. Or else the company wants to return surplus cash to the shareholders. So this might be the reason, this might be the purpose for which the company will be going for a buyback. Whenever the company goes for a buyback, then what are the sources of buyback? The company can utilize the funds from which account? The lawmaker here over says that the company can go for a buyback through its free reserves, or the company can utilize its securities premium account, or the company can go for buyback through the proceeds of an earlier issue of shares or earlier issue of some other specified securities. See, whenever a company goes for a buyback, then there are certain conditions which must be fulfilled by the company whenever the company goes for a buyback. First of all, buyback is allowed only when it is authorized by the articles of the company. Only when the articles of association allows a company to go for buyback, then only the company can go for a buyback. For that reason, the company needs to first pass a board resolution. If the company has passed a board resolution, then the company will be allowed to buy back up to 10% of paid up equity capital plus free reserves. The company can buy back up to 10% of paid up equity capital plus free reserves. However, if the company wants to buy back more than 10% of the paid up equity capital in free reserves, then in that case the company will have to pass something called as a special resolution by calling a general meeting. Sir, if we pass a special resolution, can we buy back more than 10%? Yes, but the maximum limit will be 25%. In one financial year, the company cannot buy back more than 25% of its total equity capital. After the buyback, the debt equity ratio shall not exceed 2:1. which means if the company has got a debt of 2 rupees, then against that 2 rupees, there has to be an equity of at least 1 rupee. However, if the central government notifies a higher debt equity ratio for your class of companies, then you need to follow that higher debt equity ratio. Over here, whenever the company goes for a buyback, the company can buy back all those shares or securities which are been fully paid up. The gap between the two buyback offers shall be of at least 1 year. The gap should be of at least 1 year. If the company is a listed company, then along with Companies Act, they also need to follow the provisions given under SEBI. However, if the company is not listed company, then along with Companies Act, they need to follow the rules which are being provided by central government from time to time. Over here, the company needs to give a disclosure. See, if the company is going to buy back more than 10% but lesser than 25%, then in that case the company needs to pass a special resolution, for which the company requires to call a general meeting. For calling a general meeting, the company requires to give notice of that meeting to its shareholders. The notice should include the necessity why the company is going for buyback, within what time limit the procedure of buyback will be completed, which class of securities the company is buybacking, and what is the amount the company is going to invest for this buyback. All such kinds of information will be disclosed by the company into that notice itself. Sir, what is the time period within which the buyback procedure should have get completed? The lawmaker says the buyback shall be completed within 1 year from the date of passing a special resolution or the board resolution, as the case may be. If within 1 year the procedure is not been completed, then in that case the company needs to disclose such failure, the reasons of such failure, into the director's report. In fact, a fresh board resolution or a fresh special resolution will be required in order to complete the balance procedure. Whenever the company wants to go for a buyback, the company can buy back either from its existing shareholders on proportionate basis, or else the company can buy back from the open market, or else the company can approach its employees to whom the company had issued the shares under ESOP schemes or under sweat equity shares. The company over here needs to give a declaration of solvency stating that even after the buyback gets completed, we will be solvent in nature. Such declaration of solvency should be given under a form called as SH9. Such declaration should be given to ROC as well as SEBI if the company is listed. The declaration of the solvency will be signed by 2 directors of the company. Out of them, one should be a managing director, if any. The company needs to physically destroy the securities which the company has bought back within 7 days of the last date of completion of buyback. The day when the last day of the buyback got completed, from that day within 7 days the security should be physically destroyed. In fact, the company now needs to observe a cooling period. A cooling period of at least 6 months should be observed, wherein new securities should not be issued. However, there are certain exceptional cases wherein you can issue a bonus share, or you can convert your shares into warrants or warrants into shares, or there can be something called as stock option schemes, or there can be sweat equity shares, or there can be something called as conversion of preference shares or debentures into equity shares. Such things are allowed, but a new issue is not allowed for at least next 6 months. The company over here needs to maintain a register of shares bought back. The register will be as per form number SH10, wherein the company will have to mention the details about the consideration the company has paid for buybacking the securities, the date when the name of the person got struck off from the register of member, the date when the securities were being physically destroyed, and such other details which may be prescribed from time to time by the lawmaker. Over here the company needs to intimate to the ROC as well as to the SEBI if it is a listed company under a form number SH11 stating that the procedure of buyback is being completed. Such intimation should be done within 30 days of completion of buyback. Within 30 days of completion of buyback. If any of the provisions are being contravened, then in that case the company as well as every officer of the company who is in default will be penalized. Company will be penalized with minimum 1 lakh rupee, maximum 3 lakh rupees. Every officer in default will be penalized with minimum 1 lakh rupees, maximum 3 lakh rupees. However, the provision towards imprisonment is been omitted. So this part of the penalty is been omitted. This part of the penalty is been omitted. So yes, my dear friends, we have successfully revised the provisions towards section number 68 that was about buyback of securities or shares. The last provision which we need to revise over here is the provision towards section number 71, which tells about the failure in redemption of debentures. See, at any given point of time, if the debenture trustee comes to a conclusion that the assets of the company are insufficient to discharge the liability of the debenture holders, then in that case the debenture trustee can file a petition before the tribunal. The tribunal may by order impose certain restrictions upon the company, and such restrictions will be for the betterment of the debenture holders. The second provision over here says that if the company has failed, the company has now failed to redeem the debentures, or else the company has failed to pay the interest to its debenture holders, then in that case either the debenture holders themselves or the debenture trustees will file an application to the tribunal that the company has made a default. Over here tribunal, after hearing the parties concerned, direct by order the company to redeem the debentures immediately on payment of principal amount and interest due thereon. However, if the directions of tribunal are not been followed, then yes, there used to be a penalty, but that penalty is now been omitted. That penalty is now been omitted. So yes, my dear friends, we have successfully completed the entire revisionary part towards chapter number 4 of Companies Act 2013, that was about share capital and debentures. Thank you so much.